Welcome to CM Guide podcast series. Every construction project, well, it starts with a vision, right? A carefully drawn blueprint. But as anyone who's ever built anything knows, reality rarely follows the script perfectly. Plans change. Unforeseen challenges emerge. And that's where this fascinating and sometimes, let's be honest, complex world of construction variations comes in. Today, we're taking a deep dive into how these, well, inevitable shifts are managed under two of the most widely used contracts in the industry. The FIDIC Red Book editions from 1999 and 2017, we're going to unpack everything from what actually counts as a variation to how contractors get compensated, how costs are assessed, and the pivotal, often evolving role of the engineer in, making it all work. It's really about more than just clauses. It's understanding the practical implications for every single party involved.
Absolutely. And this is a topic that genuinely can be a game changer for project stakeholders. You see, the differences between the 1999 and 2017 FIDIC Red Books, they aren't just minor tweaks. They represent quite significant evolutions. Things designed to bring greater clarity, maybe shift responsibilities a bit, and, critically, improve how disputes are managed. So for anyone navigating these contracts, understanding these nuances, well, it can prevent costly misunderstandings, and it helps build stronger project relationships too.
Okay, so let's start right at the very beginning then. When we talk about a variation in construction, it can sound like, well, any old change, can't it? But under FIDIC, there's a very precise definition. So what exactly is a variation in these contracts, and why is that formal definition so important?
That's the perfect place to kick off. If FIDIC defines a variation right there in the core of the contract, it's subclause 1.1.6.9 in the 1999 Red Book. It says a variation means any change to the works which is instructed or approved as a variation under Clause 13. That's the clause on variations and adjustments. Now, this isn't just, legalese for the sake of it. It's a fundamental concept. And it carries right through to the 2017 edition, too, so there's consistency in its core meaning.
Oh, okay.
What it emphasizes, really, is that a variation isn't just some spontaneous alteration made by a contractor on site, or even, say, a minor tweak suggested informally by the employer. It has to be formally instructed or approved by the engineer.
Oh, right. So it needs that official stamp.
Exactly. Think of it like this. Your original contract is your agreed route, A to B. A variation isn't just you decided to take a detour. It's more like the GPS formally recalculating the route and telling you, okay, here's the new way, or how to get back on track. And this formal instruction, it's absolutely crucial. Why? Because it establishes a clear, undeniable contractual process for managing these changes. Without it, you'd just open the door to endless disputes, wouldn't you? Arguments over unauthorized alterations, maybe informal agreements someone forgot about, or work done outside the contract's framework. So by embedding this procedural compliance right into the contract, FIDIC makes sure that changes are always managed within an agreed, transparent structure. It protects everyone from ambiguity and potential claims down the line.
So it's not just any change. It's a contractually managed change. That ensures everyone knows exactly where they stand. That makes a lot of sense. Building on that, the engineer clearly holds significant power here. What's the scope of their authority to instruct these variations? When exactly can they do it? And what sort of broad categories of changes fall under this power? Does it mean they have, carte blanche to change anything?
That's a really good question about the engineer's authority. And no, it's certainly not carte blanche. But their power to initiate variations is quite broad, and it's specific. Under Clause 13.1 of the FIDIC 1999 Red Book, the engineer has the authority to instruct a variation at any time prior to issuing the taking over certificate for the works.
Okay, and the taking over certificate is basically when the employer accepts the completed work, right?
Precisely. It's the formal handover document. So, essentially, the engineer can instruct variations right up until the project is formally handed over. Now, this can happen in a couple of ways. Either the engineer just directly instructs a change in writing, simple enough, or they might request a proposal from the contractor for a specific modification. Sort of saying, okay, how would you approach this change? Give us a plan.
Right.
And when it comes to the types of changes that count as variations, Clause 13.1 outlines them very clearly. It's not, an exhaustive list of every tiny detail, but it covers broad categories. Pretty much anything that might need changing on a project. First, there are quantity changes. That covers altering the quantities of any existing work item in the bill of quantities, that detailed list of work.
Yeah.
So if you need to dig out more soil or use less concrete, that's a variation.
Makes sense.
Then, quality or characteristic alterations. This is about modifying the quality or other features of any work item. Maybe the client decides they want a higher grade of finish or, I don't know, a different type of insulation. Those qualitative changes. Variations. Dimensional or positional shifts. Changes to levels, positions, dimensions of any part of the works. Imagine a building's footprint needs a slight adjustment on site because, unexpected pipes underground. Or maybe a road's gradient needs a minor tweak. That's covered. Then there's omissions of work. This one's particularly interesting. You can omit work, but, and this is critical, it applies unless the omitted work is to be carried out by others.
That's the point you mentioned earlier, so they can't just take work away and give it to someone cheaper.
Exactly. It's a really important protection for the contractor. We'll definitely dig into that one more later because it's a big source of disputes. Next up, additional work. Any new work, plant that's usually equipment or machinery materials or services needed for the permanent works. The permanent works being the actual structure being built, not the temporary stuff. This also includes things like extra tests or exploratory work that wasn't originally planned.
Got it.
And finally, sequence or timing adjustments. Changes to the sequence or the timing of how the work is executed. This gives the engineer power to alter the project schedule if needed, which of course can have big ripple effects on timelines and costs. What's absolutely vital here, though, is that the contractor is explicitly prohibited from making any alterations or modifications to the permanent works unless and until the engineer formally instructs or approves a variation.
So no freelancing.
Definitely not.
Yeah.
It highlights the strict procedural compliance that's just paramount in FIDIC contracts. It's all about control, transparency, and avoiding those ad hoc decisions that could derail everything and lead to costly arguments.
That is a truly comprehensive list, and that, unless carried out by others, point on omissions.
Yeah, very intriguing. A crucial safeguard, it sounds like. Now let's pivot slightly. Let's talk about the causes of variations and the contractor entitlements that follow. Projects are dynamic, right? And sometimes the legal framework itself shifts during a project's life. How are changes in laws handled under FIDIC? Are they considered variations? And how do they affect the price? Changes in laws, yes, that's a classic example of an external event that can really impact a project and, well, necessitate a variation. FIDIC contracts are quite clear on this. Under the 1999 Red Book, Clause 13.7 specifically, the contract price is subject to adjustment. For any increase, or decrease actually, in cost, that's the contractor's expenses resulting from changes in the laws of the country. This includes new laws coming in, old laws being repealed or modified, or even just shifts in how laws are interpreted by courts or officials. The key thing is, these changes have to happen after the base date. That date is usually set just before the tender submission. It's like a contractual snapshot in time, you see. That's the baseline against which you measure changes.
Okay, so it locks in the legal situation at tender time.
Precisely. And of course, these changes must genuinely affect the contractor's performance. So, if a new environmental rule means using a more expensive material, that's a direct cost impact. That counts. Now, here's where the 2017 Red Book introduces a really interesting evolution. That's in Clause 13.6. While the 99 version talked about cost increases, the 2017 edition explicitly states that if there's a decrease in cost due to a change in laws, the employer is entitled to a reduction in the contract price.
So it works both ways now. More balanced.
Much more balanced, yes. It introduces fairness for both sides. It's not just about the contractor getting more money when costs go up. It's a symmetrical adjustment. And there was another powerful new provision in the 2017 edition. If an adjustment to how the works are executed becomes necessary because of a change in laws, either the contractor or the engineer can trigger a variation.
Oh, interesting. So the contractor can initiate it too.
Yes. They do this by giving prompt notice with supporting details. In the 99 edition, the contractor's right to kick this off wasn't as clearly spelled out. It often felt like the employer or engineer had to make the first move. So this 2017 change really empowers the contractor to respond proactively to legal shifts.
But that word promptly sounds like it could be debated. What does prompt mean here?
Well, that's the potential point of discussion, isn't it? Generally, it means as soon as reasonably possible. But, its exact starting point could sometimes be controversial. It just emphasizes that timely action by either party is crucial to lock in those entitlements, even if a formal variation instruction doesn't follow immediately. Practically speaking, contractors need to be super vigilant about permits and regulations. Generally, permits obtained by the employer are at the contractor's expense, unless they're a direct result of a change in law. In that case, they might be reimbursable. It means keeping a really sharp eye on the evolving legal landscape isn't just good practice, it's a contractual necessity.
That promptly notice requirement definitely sounds like it could spark some interesting discussions about timing. But it's good that both sides can trigger it. Now, shifting gears a bit. Unexpected ground conditions, a classic challenge, right? Nearly every project seems to hit something surprising underground. How do FIDIC contracts deal with these unforeseeable physical conditions, and what entitlements does the contractor have? Because the ground really does love throwing curveballs.
Oh, you're absolutely right. Unforeseen ground conditions are probably one of the most common culprits for project delays and variations. FIDIC addresses this head-on. Under Clause 4.12 of the 1999 Red Book, physical conditions are defined pretty broadly. Natural physical conditions, man-made obstructions, other physical obstructions you might encounter at the site. Importantly, though, this definition explicitly excludes climatic conditions, so unusually bad weather, that's handled separately.
Okay, so ground stuff, not weather.
Exactly. And the key term here is unforeseeable. Commentaries on FIDIC clarify this, reflecting subclause 1.1.6.8 of the 99 edition. It means not reasonably foreseeable by an experienced contractor by the date for submission of the tender.
So what an experienced contractor should have figured out beforehand doesn't count.
Precisely. It's not about blaming anyone for genuine unknowns. It's about what a competent, experienced contractor, having done their homework at the tender stage reviewing site investigation reports, walking the site, understanding local geology, could not have anticipated. If they hit something truly unexpected, like, I don't know, an ancient unrecorded burial site, or a pocket of quicksand that just wasn't detectable through reasonable investigation, that's unforeseeable. If these unforeseeable adverse physical conditions pop up, the contractor has a clear obligation and also an entitlement. First, the obligation. They shall give notice to the engineer as soon as practicable. And this isn't just a casual heads up, it needs detail. The notice has to describe the conditions and explain why the contractor thinks they were unforeseeable. The engineer needs that info to make a decision and maybe issue instructions.
Okay, notice first, then what?
Then the entitlement kicks in. If the contractor suffers delay and EDOR incurs cost because of these unforeseeable conditions, they are explicitly entitled to an extension of time and/or payment of that cost. So if hitting unexpected hard rock takes an extra month and needs special drills, the contractor can claim for both the time and the money.
That seems fair.
It is. You can think of it like a decision tree. 1. Contractor hits an adverse physical condition. 2. Big question. Is it unforeseeable based on the FIDIC definition? If no, meaning it was reasonably foreseeable, well, no claim is entitled. That risk was on the contractor. But if yes, it wasn't foreseeable, and the contractor suffers delays or incurs cost because of it, then they are entitled to extension of time and/or payment. Throughout all this, the contractor has to keep working, using proper and reasonable measures. They also have to follow the engineer's instructions, even if those instructions are a variation themselves. This stops work grinding to a halt.
Right, keep the project moving.
Exactly. And one more thing on this. For the 2017 edition, there's a proactive recommendation. It suggests employers should provide a baseline report. This would outline all the known physical, geological, subsurface conditions at the base date.
Ah, like a shared understanding up front.
Precisely. It can be incredibly helpful for the engineer when assessing claims about unforeseeable conditions. It gives a clear, documented reference point for what was known at the start. It really helps streamline things and reduce disputes by having that clear baseline. It's a really smart move towards clarity, I think.
That baseline report does sound like a great proactive step. Avoids arguments later. Always a win-win. Okay, so beyond changes in law and these unforeseen physical conditions, are there other specific circumstances under FIDIC 2017 that explicitly grant the contractor rights to time and cost compensation? What other broad entitlements should contractors be aware of? Maybe things that weren't quite as clear back in 1999.
Yes, absolutely. FIDIC Act 2017 significantly expands the list of circumstances where a contractor is entitled to an extension of time, or EOT, and often additional costs as well. Subclause 8.5 is particularly robust here. It lists several key situations, really reflecting a more modern, comprehensive view of project risks. First, exceptionally adverse climatic conditions at the site. These have to be unforeseeable, looking at the available climatic data for the area. So we're not talking about just a few rainy days. It has to be weather that's genuinely unusual and severe for that location at that time of year, something you couldn't reasonably plan for.
Okay, so truly exceptional weather.
Right. Second, and this is a really key modern addition, reflecting recent global events. It's entitlement for unforeseeable shortages in the availability of personnel or goods caused by epidemic or governmental actions.
Ah, like pandemics or lockdowns.
Exactly. This provision clearly reflects lessons learned from things like widespread pandemics or state-imposed lockdowns. It gives contractors a clear path to claim time and cost for disruptions that are genuinely beyond their control due to these major health crises or government interventions. It's a crucial update, addressing a global risk maybe not explicitly considered in earlier versions.
That's very relevant today.
It really is. And then there's what I sometimes call the significant catch-all provision. This covers any delay, impediment, or prevention caused by or attributable to the employer, the employer's personnel, or the employer's other contractors on the site.
So if the employer causes the delay,
Then the contractor is covered. This is a vital protection. In many other contract forms, if the employer causes delays, the project schedule can become at large. That means the original completion date is effectively lost, and the contractor might lose their right to claim liquidated damages. This FIDIC 2017 provision is designed to stop that happening. It means if the employer is responsible for a delay, the contract doesn't just lose its completion date. Instead, the contractor gets compensated with an EOT and often costs for that delay and its consequences. It ensures the contractor doesn't carry the burden of delays caused by the other party, which maintains contractual certainty. Right, it keeps the contract structure intact. Precisely. So in summary, the 2017 Red Book introduces, well, numerous cases where the contractor shall be entitled to EOT along with additional costs and in certain situations to reasonable profit as well. Commentary suggests this includes almost 6 cases where the contractor will be entitled to costs along with the EOT, and in almost 13 cases the contractor will be entitled to EOT, cost, and profit. It clearly demonstrates a much more comprehensive, more protective framework for contractors compared to the 99 version, especially regarding unforeseen events and employer-driven delays. It's a big move towards balancing risk more equitably.
that does sound like a much more robust framework for contractors in the 2017 edition, especially with those modern editions reflecting things like pandemics. Very important. Now, let's delve into one of the most sensitive, often quite contentious areas, when work is omitted from the contract. This gets particularly tricky if it looks like the omitted work is just being transferred to another contractor. What are the contractor's protective measures? What entitlements do they have in that scenario? Because for a contractor, that must feel like a direct hit to their bottom line, their expected profit.
You've absolutely hit on a critical point. This can lead to significant disputes, no doubt about it. The foundational principle here is that a construction contract gives the contractor not just a duty to do the work, but also a corresponding right to complete that contracted work, and crucially, to realize the profits from it. Omissions, especially if they're used to transfer work, can seriously infringe upon this fundamental right. The common concern, exactly as you said, is that employers might misuse their variation power, the omission part, to switch contractors. Maybe they found someone cheaper mid-project, or they just want to split the work differently. This is a direct threat to the contractor's expected profit and, frankly, the stability of their project planning.
So what's the general legal view on this? Can employers just do that?
Well, the general legal stance, supported by cases in many common law jurisdictions, like the American case Gallagher v. Hirsch, has often held that omission means work that is not to be done at all, not work that's simply taken from contractor A and given to contractor B. If such a transfer happens, it's generally seen as a breach of contract, and that entitles the original contractor to claim for their loss of profit. This principle really underscores that a variation clause isn't a blank check for an employer to reshuffle work after the contract's awarded. It's about ensuring the original contractor gets to complete what they successfully bid on.
Okay, so the default is omission means canceled, not transferred.
That's the general starting point, yes. We also have a very significant UK case, Abbey Developments Limited, VPP Brickwork Limited. In that situation, even though the contract had a clause that seemed to allow broad variations without claim, the court really emphasized something important. They said that a convenience or omissions clause required reasonably clear words to allow an employer to transfer work from one contractor to another. This highlights a profound legal truth. If an employer genuinely wants the right to offload work to someone else later, that intention needs to be spelled out in crystal clear, unambiguous language right there in the contract.
So it has to be explicitly stated up front.
Exactly. Otherwise, it's likely to be seen as a breach, and the original contractor can claim damages for their lost opportunity. Now, let's compare FIDIC 1999 and 2017 on this specific point, because this is where a critical evolution happened, and it's really important to grasp. Under FIDIC 1999, subclause 15.5 allowed for termination at will, or termination for convenience, but it added the condition. So long as the employer does not intend to have the works executed by himself or another contractor.
Ah, so the 99 version explicitly blocked transferring the work after termination for convenience.
It implicitly restricted, yes. It put up a barrier essentially protecting the contractor's scope in that termination scenario. However, FIDIC 2017, in its subclause 15.5, actually gives the employer the leeway to terminate the contract for convenience without any restrictions. That's a big expansion of the employer's rights.
Wow. Okay. So the employer can terminate and give the work to someone else under 2017?
They can. But, and this is the absolutely crucial balancing act, the critical part, subclause 15.6b of FIDIC 2017, explicitly provides for the contractor's entitlement to loss of profit or other losses and damages suffered by the contractor as a result of this termination.
Right. So they can do it, but they have to pay for the lost profit.
Precisely. This is a monumental evolution. While the employer gets broader termination rights for convenience, the contractor is explicitly compensated for that loss of profit and other damages. It directly addresses the very concern raised by those common law cases about unfair omissions and work transfers. It means the employer can terminate for convenience and reassign work, but they have to compensate the original contractor fairly for doing so. This makes the 2017 Red Book arguably more balanced overall. It provides explicit remedies for what was a bit of a gray area, protecting the contractor's financial interests even when the scope is unilaterally cut or transferred.
That's a truly crucial distinction, the 2017 edition explicitly baking in that compensation for loss of profit in convenience terminations. That's a major clarification, maybe even a win for contractors. Now moving on to valuation. Once a variation is agreed upon, how is its monetary value actually determined? What are the standard rules for measurement and pricing under FIDIC? Because that's where the rubber really meets the road, financially speaking.
Exactly. Valuation is where the theoretical change turns into, well, a number on an invoice. The general principle for measurement, it involves determining the net actual quantity of each item of the permanent works. So how much was actually built or installed? The method for this measurement is typically expected to follow the bill of quantities or any other applicable schedules that are part of the contract. These list out the items and expected quantities. It's worth noting here, subclause 12.2 on the method of measurement itself, that's remained largely unchanged between the 1999 and 2017 editions. So there's good consistency in the approach to quantity surveying.
Okay, measure the actual quantities first, then pricing.
Right. The engineer plays a central role here. They're responsible for evaluating these work items. They take the agreed or determined measurement, the quantity, and then they apply what's called the appropriate rate or price for that item. Now, what's the appropriate rate or price? Primarily, it's the rate already specified in the contract for that particular item. If there isn't an exact match, maybe it's a completely new type of work introduced by the variation, then the rate specified for similar work is used. Or perhaps a rate is derived from other elements in the contract. The goal is always to maintain consistency with the original contract pricing structure wherever possible.
Makes sense. Stick to the agreed prices if you can.
Exactly. But there's a key addition in FIDIC 2017 in subclause 12.3. It introduces an alternative method for deriving an appropriate rate or price when existing rates just don't fit. This alternative is the reasonable cost of executing the work, plus a 5% profit margin if no specific profit percentage is stated elsewhere in the contract data.
Default mechanism for new items. 5% profit on top of reasonably cost.
Precisely. It's a practical and important default. It provides a safety net for pricing new or significantly altered items where the original contract rates might just not be suitable at all. It aims to ensure fair compensation. And as I touched on briefly before, the 2017 edition also introduced specific time limits for the engineer to agree or determine these rates. That adds more procedural discipline, stops things dragging on. This all ties into the concept of the sanctity of prices. This principle, which you see reflected in legal cases like Weldon Plant and Henry Boot, basically suggests that the overall level of the original rate itself isn't usually up for redetermination. The focus is on whether the existing rate is appropriate for the changed work, not whether the original rate was, a good deal or fair in the first place. It protects the original commercial bargain struck between the parties, even when variations happen. It says, look, we're not reevaluating your whole bid pricing now, just figuring out how this specific change fits into it.
So the original rates are basically king unless very specific conditions allow for an adjustment. That protects the initial commercial agreement. Which leads me perfectly to my next question. When can an existing contract rate actually be altered for a variation, particularly if the quantities of work change significantly? Are there clear thresholds for this, or is it more of a subjective call by the engineer?
Oh, it's far from subjective.
Yeah.
There are very specific, quite stringent conditions under FIDIC 1999, detailed in Clause 12.4. And all these conditions must be met for a new rate or price to be deemed appropriate just because quantities changed. It's not a casual adjustment, it's a precise set of criteria, designed to ensure only truly impactful quantity shifts trigger a rate renegotiation.
Okay, so what are these conditions? All four need to be met, you said.
All four, yes. Let's break them down. 1. Substantial quantity change. The measured quantity of the item has to change by more than 10% from the quantity in the bill of quantities or schedule. So there needs to be a significant deviation, not just a tiny fluctuation.
10% change. Got it.
2. Monetary significance threshold. This quantity change, when you multiply it by the specified rate for that item, must exceed 0.01% of the accepted contract amount. This adds a monetary significance test. It means minor quantity changes, even if over 10%, on really cheap high-volume items might not trigger it if their overall impact on the total contract price is negligible. It's about proportionality.
Right, it has to be financially significant too.
3. Impact on unit cost.
Yeah.
This quantity change must directly alter the cost per unit quantity of this item by more than 1%. This is crucial. It ensures the change actually has a material impact on the efficiency or the inherent cost of doing that specific unit of work. For example, if you suddenly have to excavate a much smaller quantity, your fixed costs, like bringing in the excavator, might now be spread over fewer units. That makes the cost per unit significantly higher. That's the kind of impact this condition looks for.
Okay, the cost per item has to change by more than 1%.
Yeah. Correct. And finally, 4, not a fixed rate item. The item must not be specified in the contract as a fixed rate item. If it's explicitly called out as fixed, well, then it's excluded from these adjustments, regardless of how much the quantity changes.
So 4 pretty strict hurdles to clear.
Very strict. And until such time as a new rate or price is formally agreed or determined for an item meeting all these conditions, the engineer assesses a provisional rate, just for the interim payment certificates. It's a practical measure, ensures the contractor keeps getting paid for the work while the final precise rate is being hammered out. And again, the 2017 edition added time limits for the engineer to finalize these rates, preventing things staying provisional indefinitely. These conditions, they're really designed to prevent constant, minor renegotiations while still allowing for fair adjustments when the impact on the unit cost is genuinely significant and measurable. It's all about protecting the financial integrity of the project.
That certainly clarifies the strict conditions needed for rate adjustments. It's not just a minor change. It has to be significant in several ways. Now, what about those really small or minor variations, maybe incidental tasks that just pop up unexpectedly? Is there a simpler evaluation method to avoid getting bogged down in these complex calculations for every little thing?
Absolutely. FIDI contracts aim to be practical. And yes, they do provide for a simplified valuation method for what they call work of a minor or incidental nature. It's known as the day work basis. Under FIDIC 1999, Clause 13.5, the engineer has the discretion, the power, to instruct that such a variation be executed on this day work basis. It's typically used for tasks where getting a formal quote is impractical, or maybe the scope is just too fluid to price up front. The work is then valued according to a day work schedule. But, and this is important, that schedule must be included in the contract itself. It pre-agrees rates for labor, plant, materials, usually on a daily or hourly basis.
And if there's no day work schedule in the contract?
Then the subclause simply doesn't apply. You'd have to find another way to value that minor work, maybe agree a lump sum, or use the standard variation pricing rules. The day work process itself is quite straightforward, but, and this is a common theme in FIDIC creation, it requires diligent documentation. The contractor has to submit quotations for any goods to the engineer before ordering them. That ensures transparency on material costs. And crucially, the contractor must deliver daily accurate statements to the engineer. These statements need to detail all the resources used in doing the previous day's day work.
So detailed timesheets, basically.
Pretty much. It needs to include names, occupations, and time of the contractor's personnel who worked, what they did, how long. Also, the identification, type, and time of contractor's equipment and temporary works, use what machines were on site, for how long. And the quantities and types of plant and materials use what supplies were actually consumed for that day work task. One copy of these statements, once the engineer agrees it's correct, gets signed by the engineer and returned to the contractor. These signed daily statements then become the basis. The contractor uses them to submit price statements for payment, which get included in the next interim payment certificate. It avoids the whole remeasurement and repricing exercise for minor things. Instead, it relies on a transparent record of actual resource use at those pre-agreed rates. That's a really pragmatic approach for managing those small, unpredictable bits of work.
That sounds like a much more practical way to handle small, unforeseen tasks. Ensures fair pay without getting totally bogged down in admin. Good. Now, let's circle back briefly to omitted work. We talked about the principle, but if work is omitted, especially if it was part of the original plan, how is the contractor compensated for costs they might have already incurred or for losses resulting from that omission? Because, a contractor might have ordered special materials, mobilized specific resources, only for that piece of work to suddenly disappear.
Yes, this is a critical area. Contractors can indeed incur significant, sometimes unrecoverable costs preparing for work that then gets omitted. FIDA 1999, specifically Clause 12.4 again, provides a mechanism for the contractor to claim these costs for omitted work, assuming the value hasn't been agreed upon to other means like a negotiated price reduction. There are specific conditions that have to be met for this entitlement to arise. It's essentially about protecting the contractor from being unfairly left out of pocket. First, the contractor must have incurred, or they must be able to demonstrate they will incur, costs that would have been covered by a sum within the accepted contract amount if the work hadn't been omitted.
So recognizing preparatory costs, mobilization, things like that.
Yes, exactly. It recognizes that contractors often front-load costs, have fixed overheads, or commit resources based on the expected full scope. Think about design work they might have done, procurement efforts, maybe even setting up specific areas of the site just for that now omitted work. Second, the omission of this work must result, or have resulted, in that sum not forming part of the contract price anymore. Basically, if the value of that work is removed from the contract payments, the associated costs become unrecoverable through the normal payment route.
Okay.
Third, and this is important, this cost must not be deemed to be included in the evaluation of any substituted work.
Right.
This prevents double dipping, essentially. If the omitted work is immediately replaced by something else, and the costs incurred for the first piece are actually useful for the replacement piece, then you can't claim them separately.
Right, makes sense.
So if those conditions are met, the contractor is obligated to give notice to the engineer. And along with that notice, provide detailed supporting particulars that itemize these incurred costs. Upon receiving this notice and the backup documentation, the engineer then proceeds to agree or determine this cost, and it's then added to the contract price. This clause is a clear safeguard. It ensures the contractor isn't unfairly penalized for unrecoverable costs just because the employer initiated an omission. It upholds fairness and protects the contractor's financial position against those unilateral scope changes. It's really about making sure the contractor isn't left holding the bag for preparatory work that suddenly gets scrapped.
It certainly sounds good to see that FIDIC specifically addresses those potentially sunk unrecoverable costs. That seems fair. Now, when project delays inevitably happen, especially due to variations or other events that aren't the contractor's fault, we often hear terms like prolongation costs and delay damages. They can sound a bit similar, but I gather they're quite distinct. Could you break down what each of these means and how they relate to each other?
Yes, they are indeed two distinct but related concepts. Both are crucial for assessing the financial impact of delays, and yeah, they often cause confusion. Let's tackle them one by one. Let's start with prolongation costs. These are, quite simply put, the additional costs that a contractor has incurred as a result of the completion of the works being delayed by an event that is the responsibility of the other party. Usually that means the employer.
So costs incurred because the project runs late due to the employer.
Exactly. Think of it as the extended overheads you incur because the project runs longer than planned, but through no fault of your own. Examples could be the ongoing cost of keeping the site office running utilities, security, admin staff for an extra, say, 2 months, the cost of keeping key project managers, engineers, supervisors on the project for that extended period when they could have moved on. Rental costs for equipment you expected to demobilize, but now you have to keep it on site longer, maybe increased insurance premiums or financing charges because the whole project duration is prolonged.
Okay, so the extra running costs due to someone else's delay.
That's a good way to put it. A common trigger I've seen is the employer failing to provide site possession on the agreed date. or maybe delaying in giving necessary instructions or drawings for the work to proceed. When these employer-caused delays happen, the contractor naturally racks up these prolongation costs. And it's important to link this back to what we discussed earlier. FIDIC 2017, with its broader entitlements for extension of time under subclause 8.5, often explicitly includes recovery of these additional costs, and sometimes even profit. Remember those numbers. Almost 6 cases where the contractor will be entitled to costs along with the EOT, and in almost 13 cases the contractor will be entitled to EOT, cost, and profit. This clearly connects the entitlement to an EOT with the recovery of prolongation costs for delays that aren't the contractor's fault. It's about making the contractor financially whole again.
Right, linking time extension to cost recovery. Makes sense. So what about delay damages? How are they different?
Okay, delay damages are the other side of the coin. Under FIDIC 2017, subclause 8.8, if the contractor fails to meet the time for completion stipulated in the contract, then the employer becomes entitled to payment of these delay damages. This is usually a pre-agreed amount, often called liquidated damages, stated right there in the contract data. It's paid for every single day that passes between the scheduled time for completion and the actual date of completion of the works or a section.
So this is the penalty the contractor pays for being late themselves.
Exactly. It's a pre-agreed penalty. And crucially, these damages are typically capped at a maximum amount, also specified in the contract data. This provides some certainty for the contractor about their maximum exposure. The important clarification here is that these delay damages are generally the only damages due from the contractor specifically for late completion. There are exceptions, like if the contract is terminated before completion under Clause 15.2, but generally this pre-agreed sum limits the contractor's liability for being late. It provides certainty for both sides. It's the penalty for your delay, not the cost recovery for their delay.
Okay, prolongation costs. Contractors' extra costs due to employer delay. Delay damages, employer's compensation due to contractor delay. Got it.
Precisely. And just to make prolongation costs more tangible, think about a simple numerical example. Imagine, say, reduced working hours are imposed on a site, maybe due to a new safety rule causing a delay. If this impacts, let's say, 970 units of work, the additional cost attributable to reduced working hours could be calculated. Maybe it comes out to, 120,000 ZAR, just picking a currency. This figure would be derived by analyzing how fixed and variable costs per unit change over that prolonged period. This kind of example just brings home the real financial consequences of delays and highlights why accurately assessing prolongation costs is so vital for both parties. It's real money we're talking about, not just abstract delays on a chart.
That numerical example definitely helps clarify the financial impact, makes it very tangible indeed. Now, the engineer. They're clearly a central, almost pivotal figure in managing all these variations under FIDIC. What are their overarching duties? And perhaps even more critically, how is their impartiality ensured? Especially given their role is often seen, rightly or wrongly, as representing the employer's interests primarily. That seems like a potential conflict of interest waiting to happen.
You've absolutely hit on a core tension point there. And it's something FIDIC contracts have continually sought to refine over the years. The engineer's role is indeed central. They act as an independent professional responsible for administering the contract. They're tasked with interpreting the contract documents, assessing claims, issuing instructions which the contractor must comply with, as laid out in FIDIC 1999, Clause 3.3. They are, in essence, the technical and contractual referee on-site, managing the flow of information and decisions between the employer and the contractor.
But the impartiality question is key, isn't it? How is that handled?
It's absolutely key. And there's been a critical, really significant evolution between the 1999 and 2017 editions on this very point. Under FIDIC 1999, the engineer was certainly expected to act fairly and impartially. This was particularly emphasized in the context of referring matters to a dispute adjudication board, or DAB, that independent panel set up to resolve disputes. But it was more of an implied standard, often tested disputes, and sometimes, let's face it, perceived as difficult to maintain given the engineer is appointed and paid by the employer.
Right, the who pays the piper issue.
Exactly. However, FIDIC 2017 takes a monumental step forward here. In subclause 3.7, specifically covering the agreement or determination processes, which includes most engineer decisions on claims and variations, it explicitly states the following. The engineer shall act neutrally between the parties and shall not be deemed to act for the employer.
Wow, shall act neutrally, not deemed to act for the employer. That's pretty direct.
It's incredibly direct. This isn't just a polite suggestion for the engineer to try and be fair. It's a contractual mandate. This codified neutrality significantly strengthens the engineer's role as an unbiased decision-maker when evaluating claims and variations. Think about the power shift that represents. No longer just perceived, perhaps, as the employer's agent in these decisions, the engineer becomes a truly independent arbiter by contractual definition. That changes everything about trust and the dynamics of dispute handling on site. It's a formal declaration that their professional judgment shouldn't be swayed by who hired them, aiming to foster much greater confidence from the contractor side.
That's a huge change, establishing that neutrality contractually.
It is. And it's also worth remembering, while the engineer holds significant authority, the employer isn't off the hook. They also have specific obligations to provide reasonable assistance. Things like obtaining copies of relevant local laws that aren't easy for the contractor to get, and ensuring financial arrangements are properly in place and maintained to pay the contract price on time. These support the engineer's role and reinforce a more balanced contractual relationship overall.
That explicit neutrality in 2017 really is a big change for ensuring fairness. It truly reframes the engineer's role in those key decisions. Could you walk us through the specific process the engineer follows now when a matter needs to be agreed upon or determined, especially highlighting any differences between the 1999 and 2017 approaches? It sounds like there's been a definite move towards more structure in the 2017 version.
You're absolutely right. There's been a clear move toward a much more structured, transparent, and frankly proactive process in the 2017 edition. The engineer's core duty in both editions remains to agree or determine any matter or claim. That's fundamental. But how they do it has evolved. Under FIDIC 1999, subclause 3.5 basically just stated that the engineer should agree or determine the matter. It left the specifics of the process somewhat open to interpretation. Often this meant the engineer might investigate, make a decision, issue it, and then the parties would react, potentially disputing it later.
So more reactive, perhaps.
Perhaps, yes. Or at least less formally structured in the run-up to the decision. However, FIDIC 2017, under subclause 3.7, details a significantly enhanced and much more prescriptive procedure. This is a crucial area of improvement, really designed to foster agreement first and prevent unnecessary escalation. The process now clearly starts with consultation, 3.7.1. The engineer is explicitly required to consult with both parties jointly and/or separately. They have to actively encourage discussion, trying to reach an agreement. The engineer is expected to kick off this consultation promptly to allow enough time to meet the time limits that follow. And crucially, unless both parties agree otherwise, the engineer must also provide both parties with a record of this consultation.
So forcing a conversation first.
Exactly. It really pushes for a more collaborative dispute avoidance approach right at the start. It's about getting the parties talking together, facilitated by the engineer rather than the engineer just going away and deciding in isolation. Now, if after this consultation no agreement is reached within specified time limits, 3.7.3, the default is often 42 days, but it can be varied. Or maybe the engineer gives notice sooner saying agreement isn't possible, then the engineer must proceed to make a determination.
Okay, so there's a deadline for agreement.
Yes. It ensures matters don't just drift unresolved indefinitely. It forces a decision if consensus can't be found. Finally, if agreement isn't reached, we get to the determination, 3.7.2 itself. The engineer then makes a fair determination of the matter or claim. This has to be done strictly in accordance with the contract, and they must take due regard of all relevant circumstances. This determination must be detailed. It has to provide clear reasons supporting particulars, and it's formally issued as a notice of the engineer's determination. The contrast with the 1999 approach is pretty stark. The 2017 edition puts a much greater emphasis on that joint consultation and a structured attempt at agreement before the engineer makes a unilateral determination. It aims for a more transparent, collaborative environment, trying to resolve issues earlier and hopefully with greater buy-in. It's a deliberate shift, you could say, from a potentially more directive role to a more facilitative one, at least initially.
That structured approach in 2017 formal consultation, clear time limits, really sounds like it could streamline the whole dispute resolution process and definitely encourages that upfront engagement. That's got to be positive. Now, throughout this discussion, notices have come up again and again as being absolutely crucial. You've stressed their importance. Just how important are they really? What are the specific requirements? And perhaps most importantly, what actually happens if they are not followed strictly? Because this sounds like a potential minefield for contractors and maybe employers too now if they slip up.
You've hit on probably one of the most vital yet frequently underestimated aspects of FIDIC contracts: the absolute paramount importance of proper and timely notices. For parties to protect their rights, their entitlements under these contracts, whether it's time, money, or other relief, giving notices correctly and on time is utterly essential. Let me be absolutely clear on this. Failure to do so can, and often does, undoubtedly prejudice rights and entitlements.
So, miss a notice, potentially lose your claim.
That's exactly the risk. This is not just a bureaucratic formality. It's a strict procedural gateway to making almost any claim under the contract. You could have the most watertight, substantively strong claim in the world, but if you failed to give the required notice correctly and on time, you might very well lose the right to pursue it. It's that serious. Under FIDIC 2017, they've tried to leave no room for ambiguity about what constitutes a valid notice. The requirements are very specific. It must be in writing. Obvious, maybe, but essential. It must explicitly state that it is a notice. So just an email saying, "We've got a problem here," might not cut it. It needs that label.
Okay, clearly identify it.
Yes, it must reference the relevant subclause under which it's being given. Which part of the contract are you triggering? It must describe the event or circumstances that have arisen. What actually happened? It must comply with any specified time limits. Crucial. And importantly, it must be signed by the authorized representative, the contractor's representative for contractor notices, or typically the engineer for employer notices under the Red Book.
That's quite a checklist.
It is. And that level of detail is key to its validity. For contractors' claims, there's that well-known 28-day notice period. That's in subclause 20.1 in the 99 edition and 20.2.1 in the 2017 version. That clock starts ticking from when the contractor became aware, or realistically should have become aware, of the event or circumstances giving rise to the claim. It means you can't just sit on a problem hoping it goes away. You have to act promptly.
28 days isn't very long in project terms.
It really isn't, which underlines the need for vigilance. Now, here's where FIDIC 2017 introduces a really significant and I think important safeguard for the contractor. It concerns the engineer's initial response to a claim under subclause 20.2.2. If the engineer thinks the contractor failed to give that initial 28-day notice of claim on time, the engineer must issue a notice back to the claiming party, explaining why they think it's late within 14 days of receiving the claim.
Wow. Okay, so the engineer has homework too, a deadline to object.
Exactly. This is a new obligation on the engineer, and here's the critical part, the real game changer. If the engineer fails to issue this 14-day notice, challenging the timeliness of the contractor's notice, then the contractor's notice of claim is deemed valid regarding timeliness.
Seriously? So if the engineer misses their deadline, the contractor's notice is accepted as timely?
That's what the clause says. It places a clear obligation on the engineer to act promptly if they believe a notice is late. It protects the contractor from an unresponsive or maybe just very busy engineer who might otherwise let the time bar pass silently and then dismiss the claim later purely on timing grounds. It forces prompt action and response from both sides.
That's a huge procedural point.
It really is. However, the legal world is complex, right? While FIDIC emphasizes strict compliance, broader legal principles might sometimes come into play, depending on the governing law of the contract. For instance, in some civil law jurisdictions, you might find a principle like good faith in fulfilling contractual obligations. Article 1481 of some civil codes, for example. You could argue this principle might apply if, say, a contractor provides all the crucial information about an issue through detailed meeting minutes or maybe progress reports, and the engineer and employer clearly acknowledge this information and even act on it, even if it wasn't labeled as a formal notice. The argument could be, well, the purpose of notification, making sure the other party knew what was going on, was fulfilled, and rejecting the claim later purely on a technicality, because it wasn't labeled notice, might be seen as acting in bad faith.
Interesting angle. Purpose over form.
Potentially, yes. Similarly, the principle of estoppel might come up. Think of estoppel like this. If I consistently let you bend a rule and you rely on that, I might be estopped or prevented from suddenly enforcing that rule against you later without warning. So if an engineer accepts a claim from a contractor, maybe starts evaluating it even though it arrived after the contractual deadline, they might be estopped from later turning around and rejecting it solely on the grounds of late notice. Their actions or lack of immediate rejection could imply they waived their right to strictly enforce the notice period in that instance.
So actions can speak louder than clauses sometimes.
In some legal interpretations, yes. It highlights this delicate balance. On one hand, you have the strict contractual compliance that FIDIC champions for certainty. On the other, you have these broader principles of fairness and equity that legal systems might apply to prevent purely technical, perhaps unjust outcomes. It means parties need to be incredibly diligent with notices, absolutely. but also be aware of this broader legal context that could potentially, in some situations, temper the strict application of time bars. It's complex.
That's a truly fascinating interplay between the strict contract terms and those broader legal principles like good faith and estoppel. It genuinely underscores the need for deep knowledge and very, very careful navigation of these contracts. As we move towards wrapping up our deep dive here, what would you say is the overarching philosophical shift between the 1999 and the 2017 Red Books, specifically regarding contract administration and handling variations? Beyond all the specific clause changes we've discussed, what's the big picture you want listeners to really take away?
I think the overarching philosophical shift, the big picture takeaway, when you compare FIDIC 2017 to its 1999 predecessor, is a really decisive move towards significantly greater prescriptiveness. The 2017 edition is, well, considerably more prescriptive, as many commentators note. It introduces much greater detailed processes for establishing entitlements to additional payment and/or extensions of time. The clear aim here seems to be enhancing clarity, predictability, and hopefully reducing ambiguity in how the contract is administered day to day. In essence, it leaves less room for subjective interpretation or informal understandings. It relies much more heavily on defined step-by-step procedures that must be followed. It's almost like moving from a somewhat flexible playbook, maybe, to a very detailed, quite rigid instruction manual. More rules, less wiggle room. That's a fair summary, yes. And accompanying this, the 2017 edition also contains numerous new time bars. We've talked a lot about the notice periods, but there are others too. This reinforces that critical importance of rigorous procedural compliance, not just for the contractor, but for the employer too now. While this might seem burdensome at first glance, the underlying intention is positive, I believe. It's designed to bring certainty, to accelerate dispute resolution by forcing issues to be raised early, and crucially to encourage prompt communication and action from both sides. It basically says, if you have a claim or a concern or an objection, you need to raise it formally and you need to raise it quickly. Don't let things fester. So fundamentally, the 2017 contracts are just more demanding. In terms of record keeping, notice giving, timely communication from both the employer and the contractor, it's a definite shift from maybe a more principles-based approach in some areas of 99 to a much more rules-based one in 2017. Seeking to minimize disputes through clear, detailed, and often non-negotiable processes.
That move to greater prescriptiveness certainly sounds like it demands much more vigilance and discipline from everyone involved. No doubt about that. Now, how did the concept of fitness for purpose evolve between the two editions, and how does this affect variations, especially for a contractor who might have some design responsibility?
Ah, yes, fitness for purpose. This is a subtle but actually very important change. It significantly impacts the contractor's design responsibilities, if any, and how variations interact with them. Under the FIDIC 1999 Red Book, the fitness for purpose obligation, if it existed, tended to adjust somewhat automatically when a variation changed the effect of the contract.
So it changed the work, the required purpose changes too, implicitly.
Kind of, yes. If you varied the work, the purpose it was intended to achieve would often implicitly change along with it, and the contractor's obligation to meet that modified purpose would adjust accordingly. It was somewhat fluid, perhaps relying a bit on implicit understanding or interpretation. However, FIDIC 2017 introduces a crucial and I think more protective change for the contractor in this regard. If a variation is intended to impact the fundamental purpose for which the works are intended, that variation must specifically amend the employer's requirements. Remember, the employer's requirements is that core document setting out exactly what the employer wants the finished project to do, its function, its performance standards.
Okay, so the core purpose document has to be formally changed.
Yes, that's the key safeguard. If the employer's requirements are not explicitly changed by the variation instruction, but the variation itself affects the contractor's ability to achieve the original intended purpose as defined in those requirements, well, then the contractor actually has grounds to refuse to comply with that variation instruction.
Really? They can refuse?
Under those specific circumstances, yes. This shift places a much greater onus on the employer. If the employer wants to fundamentally alter the purpose or function of the works through a variation, they must formally update that core employer's requirements document as part of the variation. Otherwise, the contractor is protected from being forced to deliver something that serves a different purpose without that explicit contractual amendment. It ensures the contractor's design liability, if any, remains strictly tied to the contract's defined purpose, unless that purpose is formally altered. It means no more implicit changes to core functionality through variations. It has to be explicit.
That's a truly significant shift. Puts more responsibility squarely on the employer to clearly define any changes to the fundamental purpose. Very clear. Now, we touched on this, but just to be crystal clear, are claims only a contractor's responsibility? Or did the 2017 edition really introduce more balance, making the employer equally accountable for following claims procedures?
This is indeed another significant and I think very welcome change in FIDIC 2017. It brings much-needed symmetry to the whole claims process. In the 1999 edition, let's be honest, the burden of following strict claims procedures largely fell on the contractor. While the employers certainly had rights to make claims or deductions, the procedural requirements weren't always applied as rigorously or explicitly to them. However, FIDIC 2017 introduces the crucial principle that the employer now bears the same obligations as the contractor when making a claim.
Okay, leveling the playing field procedurally.
Exactly. What this means in practice is if the employer wants to see additional payment from the contractor, or maybe claim a reduction in the contract price, or perhaps wants an extension of the defects notification period, they must also adhere to equally strict requirements. This includes giving proper notices, those same formal, timely notices with all the requirements we discussed. It includes maintaining contemporary records of the events and costs involved, and submitting detailed particulars to substantiate their claims, just as the contractor is required to do for their claims.
So no more just deducting money without the same level of proof.
That's the intention. It creates a far more symmetrical and balanced claims procedure. It demands diligence and procedural compliance from both sides of the contract. It aims to prevent a situation where an employer might make claims or deductions without providing the same level of substantiation, timeliness, or formality that's expected from the contractor. It's a major step towards, you could say, contractual equality in the claims process.
That symmetrical claims procedure definitely sounds like a major step towards fairness, demanding rigor from everyone. Good. We briefly touched on the engineer's impartiality earlier as well, highlighting that big shift in 2017. But just how explicitly is this neutrality defined in the newer edition? Is it really more than just an expectation now? Is it effectively a legal obligation under the contract?
Oh, it is absolutely more than just an expectation now. It's framed as a fundamental contractual obligation. While fairness and impartiality were certainly implied and generally expected of the engineer under FIDIC 1999, which was a good starting point, don't get me wrong, FIDIC 2017 takes it to the next level by explicitly mandating this neutrality. Subclause 3.7, as we discussed, states unequivocally that the engineer shall act neutrally between the parties when carrying out those crucial duties related to the agreement or determination processes.
Shall act neutrally. Very strong wording.
Very strong. It isn't just a suggestion or a guideline. It's a powerful formalization of the engineer's required independent role in those specific functions. It's a direct instruction within the contract for the engineer to consider both parties' positions without bias when making decisions or determinations on disputed matters. And that's absolutely vital for fostering trust and ensuring efficient, equitable contract administration. It solidifies the engineer's position, contractually, as an unbiased decision-maker in those key moments, which really strengthens the credibility of their decisions for both the employer and the contractor. It aims to remove that perception of inherent bias.
As we wrap up this really insightful deep dive into FIDIC variations, what would you say is the single most important takeaway for anyone dealing with the 2017 framework, particularly thinking about notices and procedures? If you had to boil it all down to one crucial piece of advice, what would that be?
Okay, the single most important takeaway, especially under these more prescriptive FIDIC 2017 conditions, it has to be the absolute, non-negotiable criticality of strict adherence to procedural compliance. Particularly regarding notices, that really is the golden rule now. Failure to adhere strictly to the requirements for giving a notice, or maybe responding with a notice of no objection, or expressing disagreement with a notice of dissatisfaction. Any failure in these procedural steps will, as the commentary strongly suggests, undoubtedly prejudice rights and entitlements, whether that's to extensions of time, additional payment, or other relief under the contract.
So follow the procedures to the letter or risk losing out, basically.
That's the stark reality of it. The 2017 Red Book demands a much higher level of vigilance, meticulous detail record-keeping, and proactive formal communication from both the employer and the contractor. It means that simply having a substantively strong claim, a really good case on the merits, might not be enough anymore. If you don't follow the procedural steps, precisely giving the right notice in the right format to the right person, within the right time frame, you genuinely risk losing your entitlement entirely. Procedural compliance has effectively become just as crucial as the substance of the claim itself under FIDIC 2017. So my one piece of advice, if you're working under FIDIC 2017, make absolutely sure your entire team understands the notice requirements inside out, Have robust systems in place to ensure they are met without fail. And honestly, err on the side of giving notice, even if you're slightly uncertain. Because your contractual rights and ultimately your project's financial health truly depend on getting those procedures right. Don't let a technicality derail all your hard work. It's just too big a risk to take.
Before you go, please don't forget to share, like, or subscribe. Also, have a look at other episodes and visit CM Guide website for better insights on this topic.